this was a decision of the Higher District Court of Karlsruhe, which was delivered in the beginning of October last year. The Higher District Court of Karlsruhe is the appeal court which would deal with appeals from the District Court of Mannheim. Whether in the present case this decision was in the same proceedings, basically whether this decision covered the appeal proceedings coming from the ruling from Mannheim we discussed already, it's not 100% sure. What is, however, very interesting is that the court of Karlsruhe, the Higher District Court of Karlsruhe, directly referred to this decision. And as we're going to see, it took a different view on whether protective measures should be granted here or not. In this decision, the court said basically that the signing of an NDA between the parties and the existence of an NDA between the parties does not exclude protective measures. So even if there is an NDA in place, this does not mean that the court is prevented from granting protective measures to protect information in the proceedings. This is something that can happen if the conditions are met. So the court here took the different, the totally opposing position to what the Mannheim court had said in the judgment we discussed before. And the main point here was the issue of third parties. Here, the court found that it's not sufficient just to say that the NDA is enough and that it covers the opponent, so that should be enough, and nothing above that should apply in the proceedings. So you should not have, let's say, protection also towards third parties, because it saw some practical difficulties here, and which in the eyes of the Higher District Court did not really match with the reasoning behind this framework for protection of confidentiality in trial. So, of course, the court noted here that the NDA is not binding for third parties involved in the proceedings, which means that if there are no court protective measures, you have basically no protection towards third parties. And this is not satisfactory in the eyes of the High District Court, because it gave an example here. What would happen if a third party would ask to inspect the files of the proceeding? If there is an NDA there, but no protective measures ordered by the court, then the court would have basically no basis to protect confidentiality towards this third party requesting file inspection. It would need to disclose the whole file without any reductions or something like that, and there would be no duty to protect confidentiality. And this is something which in the eyes of the court does not match with the actual reasoning and the purpose of the provisions that aim at protecting confidentiality in trial, and especially the new provision in the Patent Act, which was enacted a couple of years ago. The High District Court of Karlsruhe found, on the contrary, that the new Patent Act, these provisions aim at minimizing the risk of disclosure of confidential information, both towards the opponent and other persons involved in the trial. And in so far, it disagreed with the view that the court in Mannheim had taken before, by saying that, yes, you could have also protection towards third parties, but this is not really what the law intends to do. It's just a reflection of the primary objective of the law, and not basically sufficing in its own to justify protective measures in the proceedings. The court did not take this view here. It saw in the protection of confidentiality towards third parties an equally, let's say, important reason as in the protection of confidentiality towards the opponent in the proceedings. The fact that, as the law is structured now, only the opponent could potentially object orders that the court would take to protect confidentiality did not play a role in the eyes of the court here, or did not really change the fact that the idea behind the new provisions is to also offer protection against third parties in the proceedings. And having said that, it turned to the question which was the central question in the decision of the Mannheim court before, whether there's a legitimate interest to seek protective measures if there is an NDA there. And it said, yes, this can be the case. The fact that you have an NDA in place between the parties does not per se exclude a legitimate interest to seek protective measures. So here again, the totally different view compared to the view taken by the Mannheim court before. What the court also said here is that this new provision of the in the Patent Act expands confidentiality protection in patent infringement trials, which also means that protection that you might have under other provisions that are already in place, for example, as we said already, potential provisions coming from administrative law, especially when the court or the court personnel is involved, or from penal law. This does not exclude basically ordering confidentiality measures in the proceedings, because the new provision in the Patent Act wanted to go beyond existing rules. So here you have basically a more a higher threshold of protection, and this the scope is also broader. So this is something which the court thought the new provision brings with its extended scope of protection. And it then added that this is basically what the lawmaker also expressed in the reasoning behind the new provisions, and this is something that the court should also respect, so that you should not basically try to limit through interpretation the scope of protection that the lawmaker wanted to introduce with these new provisions in the Patent Act. So again, here a different view taken by the court, and this is the High District Court of Karlsruhe, which means that its view might be a little bit more have a stronger impact in how these cases are dealt with. We have not seen the High District Court of Karlsruhe taking any comments, at least in this decision, making any comments, at least in this decision here, of how broad the scope is and what type of information might be subject to this type of protective measures, as the Mannheim court had done with its remarks in this decision we discussed before. So here we might see that this will be clarified in further decisions in the future, and maybe this can also be something to be clarified by the Federal Court of Justice at some point. Again, here, not to forget, this is a framework which is relatively new, and especially when it comes to front cases and patent infringement cases, this is something that has been in force for almost 2 years now. So the case law has not settled here definitely yet, but these are two indications of where the path would potentially lead us in terms of protecting confidentiality in front trials. Of course, we will take a look at that, monitor that, and if we have decisions also from the higher instances, we will add this in our webinars and report about that.